All right, 2 words that changed the entire trajectory of this case overnight, she recorded. Not metaphorically, not in the sense that she kept notes or preserved emails, although she did both of those things. Pam Bondi recorded phone calls, actual audio. Conversations that took place on lines that everyone inside Trump's circle believed were secure, private, and completely untraceable. Federal agents received the files Tuesday night. By Wednesday morning, 3 prosecutors had listened to every second of every recording, 23 separate calls, 11 hours and 14 minutes of audio. All captured between February and September of 2025, all stored on a personal device that never touched a government network. I have been inside the filings related to these recordings since last night. 3 hours of reading, 2 complete passes through the supplemental exhibits filed Wednesday morning. What I found in those exhibits is what this entire breakdown is about. Because the headlines are going to tell you Bondi had recordings. What the headlines are not going to tell you is what is actually on them. Who is speaking, what they are discussing, and why prosecutors moved to seal 4 of the 23 recordings within an hour of receiving them. That sealing pace alone tells you everything about what those 4 calls contain. If you want this kind of breakdown the moment filings drop, subscribe right now and turn on notifications. This story just shifted into a gear that nobody predicted. I am covering every development in real time. Subscribe. Let's get into it. Here is why recordings are different from everything else Bondi has provided so far, and why Trump's legal team has a problem that no motion can fix. Documents can be challenged on interpretation. A wire transfer confirmation shows money moved, but it does not tell you what the people moving it were thinking. Testimony can be attacked on credibility. Bondi has immunity. She has incentive. A good defense attorney can work with that. Recordings cannot be cross-examined. They cannot be impeached. They do not have incentives or immunity deals or reasons to embellish. They are the thing itself. The words as they were spoken in the moment they were spoken. The obvious historical parallel is Nixon. But this is structurally different in a way that matters enormously. Nixon's tapes were subpoenaed from a government recording system that the White House controlled, that created months of legal battles over executive privilege and ownership. Bondi's recordings were made on her personal device, stored at her private residence, and surrendered voluntarily as part of her cooperation agreement. There is no privilege claim that attaches to them the same way. There is no government system to fight over. She made them. She kept them. She handed them over. Prosecutors now have 11 hours of audio that exists outside every privilege argument Trump's attorneys have been constructing for months. That is not an incremental development. That is a collapse of the entire defensive architecture. The filings describe Bondi's method with a level of detail that tells you this was not improvisation. She used a personal phone, not her government-issued device. Not a phone connected to any federal communication system. A separate device registered under her personal name, purchased months before she began recording, maintained on a private account that was never disclosed on any government inventory. The application she used, according to the supplemental exhibits, was a commercially available encrypted recording app that timestamps each file automatically, logs call duration, preserves original audio metadata, and stores everything locally with no cloud synchronization. She chose an app that kept files on the device itself. Nothing uploaded, nothing synced to a server that could be subpoenaed or hacked or flagged by an internal review. Every file stayed on hardware she physically controlled. This matters because Bondi was not some staffer acting on impulse. She was the Attorney General of the United States. She understood federal evidence rules from the inside. She understood chain of custody requirements. She understood what would be admissible in a federal proceeding and what would get thrown out on a technicality. The way she captured and stored these recordings satisfies every evidentiary threshold that prosecutors need to clear. The metadata is intact. The timestamps are verifiable. The audio has not been edited or transferred through systems that would compromise its integrity. Nobody around her suspected it because there was nothing to suspect. A personal phone in a pocket. An app that runs silently. No behavioral change. No unusual habits. She sat in the same rooms, took the same calls, attended the same meetings. The only difference was that she pressed record. And she did it 23 times across 7 months, with the discipline of someone who had decided very early exactly how this was going to end. The earliest recording in the batch is dated the 11th of February 2025, 3 days before the Mar-a-Lago meeting that Bondi described in her previous testimony. 3 days before, 8 people sat in a room and discussed a $340 million transaction that was never supposed to be documented. The February 11th call lasted 4 minutes and 22 seconds. 2 participants, Bondi on one end, a senior advisor to Trump on the other, identified in the filing by title but not by name because the name is under seal. The conversation opened with what the transcript describes as routine scheduling discussion. 2 minutes of logistics. Where the Saturday meeting would take place. Who would attend? What time to arrive? Then, at the 2-minute and 47-second mark, the conversation shifted. The advisor told Bondi that the structure they had discussed the previous week needed to be finalized before the Saturday meeting so that everyone in the room would already understand the framework. The specific language used, according to the filing, referenced keeping the layers clean and making sure the threshold numbers work before anyone sits down. Keeping the layers clean. Making sure the threshold numbers work. That language, captured 3 days before the meeting where Bondi's handwritten notes documented the phrase, "they know the thresholds stay under," establishes something that prosecutors have been trying to prove since the beginning of this case. The structure was not improvised at the February 14th meeting. It was planned in advance. Discussed on a call that both participants believed was private and recorded by a woman who already knew she might need proof of exactly this conversation someday. That February 11th call was recording number 1. There were 22 more after it. 4 of the 23 recordings were flagged by prosecutors within the first hour of review and sealed immediately. All 4 took place between March and June of 2025. All 4 involved calls that occurred within 48 hours of meetings already documented in Bondi's earlier testimony. The handwritten notes, the 47 emails, the wire transfer confirmations, every piece of evidence Bondi provided in her first round of testimony now has a corresponding audio track. The March 9th recording captures a 2-minute call that took place the evening after a meeting Bondi previously described in her sworn testimony. A meeting where payment routing through the Nevada holding company was discussed in detail. The document showed $18.2 million moving through a company that existed for 17 days. The recording from that same night captures 2 individuals discussing whether the dissolution timeline was fast enough or whether they needed to accelerate it. They used the phrase, "close it faster before anyone looks twice." That phrase connects directly to the corporate filing records that show the Nevada company was dissolved 11 days after the final payment cleared. The document showed the money moving. The testimony explained why it moved. The recording captures the moment someone decided how quickly the trail needed to disappear. A June recording, one of the 4 that prosecutors sealed, reportedly captures a conversation about restructuring the Qatar transaction after an internal review flagged the original arrangement. The filing references a participant stating on the call that the split needs to stay below the number. Below the number. The same threshold referenced in Bondi's handwritten notes. The same regulatory limit that CFIUS review would have triggered. Intent is no longer inference. It is audio. Prosecutors do not have to ask a jury to imagine what these conversations sounded like. They can press play. The filings identify participants on the 23 recordings by title, position, and in some cases by name. 8 of those participants overlap directly with the 8 individuals Bondi named during her earlier testimony. Every single person she placed in the room is now also on tape, but the recordings added 4 names that were not in the original testimony. 4 people who were never mentioned in Bondi's sworn account, never referenced in the 47 emails, never connected publicly to any element of this case. People who, until Wednesday morning, had every reason to believe they were invisible in this investigation. They are not invisible anymore. By Wednesday afternoon, 2 of the 4 newly identified individuals had retained criminal defense counsel. Neither had been contacted by prosecutors, neither had been named in any public filing. They hired lawyers before anyone came looking for them. Consider what that tells you about what they know is on those recordings. A third individual, described in the filings as a current senior administration official, released a 4-sentence statement through a spokesperson denying any involvement in financial arrangements of any kind. Nobody had accused this person of anything publicly. The statement arrived before the accusation. The fourth individual has gone completely silent. No statement, no spokesperson. No social media activity since Tuesday night, when someone who is normally visible goes dark at the exact moment their voice appears on a federal recording they did not know existed. The silence is not ambiguous. It is the sound of someone on the phone with a lawyer being told to say absolutely nothing until the exposure is fully understood. The 8 original names now have audio confirmation, 4 new names have entered the case, and the people those names belong to are reacting in ways that tell you they already know exactly what prosecutors are going to hear. Trump's legal team filed an emergency motion Wednesday afternoon, arguing that every recording should be suppressed. The argument has 3 layers, and the strongest version of it deserves serious examination rather than dismissal. First, they argue Bondi recorded without the consent of the other participants. Federal wiretapping law under Title III requires that at least one party to a conversation consent to the recording. Bondi was that party. She consented by pressing record. In every jurisdiction where these calls took place, one-party consent is the legal standard. The defense knows this, which is why their motion spends only 2 paragraphs on wiretapping and the remaining 14 on the second argument. Executive privilege. The claim is that a sitting attorney general recording private communications with the president and senior advisors violates the constitutional protection around executive deliberations. This is the strongest version of the argument, and it is not frivolous. Executive privilege exists for a reason. Presidents need to be able to have candid conversations with their advisors without fear that every word is being captured for future use. That principle is real. But it has a boundary that has been established through decades of case law. Privilege does not attach to communications made in furtherance of criminal activity. That is not a new doctrine. It was affirmed during Watergate. It was applied in the Clinton investigations. It has been upheld at every appellate level. If prosecutors can demonstrate that the conversations on these recordings were part of or in furtherance of the conduct under investigation, privilege falls away entirely. The third argument is procedural. The defense claims the recordings were not properly preserved under federal evidence standards. The filings from Bondi's legal team directly contradict this with forensic certification of metadata integrity, unbroken chain of custody documentation, and third-party verification that no audio was altered. Every layer of the defense motion has a structural problem, and the biggest problem is the one that no motion can solve. The recordings exist. Suppressing them from trial does not suppress them from the investigation. Prosecutors have already heard every word. 4 of the 23 recordings are under seal. Prosecutors requested the seal within 1 hour of receiving them. That pace is not normal. Standard sealing requests go through routine channels. These were filed on an emergency basis, with a judge who granted them the same evening. The filings offer limited description of the sealed recordings, but what they do say is precise enough to draw conclusions from. All 4 involve calls that took place between April and July of 2025. All 4 are described as involving participants whose identities have not yet been disclosed to subjects of the investigation. That language is critical. It means there are people on those recordings who do not yet know they are on those recordings. Prosecutors are protecting the element of surprise. They are setting up approaches to individuals who currently believe they are outside the scope of this case. The moment those names become public, those individuals lawyer up, coordinate responses, and potentially align their accounts with others who are already exposed. Prosecutors want to reach them first. This follows the identical pattern from Bondi's earlier testimony. 2.5 hours of her sworn account were sealed. The portions that remained under seal the longest were the portions that led to the most significant subsequent developments. The sealed material is always where the next phase of the investigation lives. 4 sealed recordings, participants not yet notified, emergency sealing granted the same night. Whatever is on those 4 calls is what prosecutors are building toward right now. And the people whose voices are on them are living through their last days of believing no one is listening. When those seals break, and they will break, the next wave of this case begins. Everything that has happened so far, the testimony, the documents, the public recordings, has been the foundation. The sealed four are the structure prosecutors are building on top of it. For the case, audio evidence compresses timelines in a way that nothing else can. Documents require authentication hearings. Testimony requires credibility battles. Recordings require a speaker and a play button. Prosecutors can now present a jury with the actual voices of the people involved, saying the actual words that establish intent. That eliminates months of procedural maneuvering that the defense would otherwise use to contest what was meant, what was understood, what was implied. The suppression hearing is scheduled for next Thursday. The privilege arguments go before the judge Tuesday. If both fail, and the weight of legal analysis says they will, prosecutors have 23 recordings entering the evidentiary record of a case that was already accelerating before the audio existed. For the country, the implications extend far beyond this investigation. A sitting attorney general recorded a sitting president and his senior advisors across 7 months without detection. Those recordings are now in federal hands. That fact rewrites the assumptions governing every sensitive conversation that happens inside every future administration. A former White House counsel said on Wednesday night that the chilling effect of this development cannot be overstated. Every future official who sits in a room where policy is discussed, where strategy is debated, where decisions are made, will now carry the awareness that the person across the table might be building a record. A constitutional law professor at Columbia described it as a permanent structural change to how executive power operates in practice. The trust architecture inside the executive branch has been fundamentally compromised. A former assistant U.S. attorney with 20 years of federal prosecution experience said Thursday morning that the recordings represent the single most significant evidentiary development in a case involving a sitting or former president since the Nixon tapes. The difference is that these recordings were made voluntarily by someone who chose to create them. That makes them more dangerous, not less. Here is why this matters to you directly, regardless of where you stand politically. The ripple effects of an investigation at this scale do not stay inside a courtroom. They move into markets. They move into investor confidence. They move into the regulatory frameworks that every business in this country operates within. Defense contractor stocks have already dropped. Foreign investment review processes are being scrutinized across every sector that touches government contracting. If you have a retirement account, if you hold index funds, if your livelihood connects in any way to industries affected by federal regulatory uncertainty, you have exposure to what happens next. When institutional instability accelerates, the one thing you can control is your own financial position. One opportunity worth knowing about right now: Amazon is currently giving away $750 gift cards to eligible residents in the US, UK, Canada, and Australia. It is a promotional giveaway that is open right now to anyone who qualifies. Whether you put it toward essentials, household supplies, or use it to offset some of the rising costs that come with this kind of economic uncertainty, $750 is not nothing. You can enter by clicking the link on the channel page or by scanning the QR code that will appear on screen. If you want to scan it, just open your phone camera, point it at the square on screen, and tap the link that pops up. If you are watching on your phone, just tap the channel profile picture to go to the channel page where you will see the link. A screenshot will appear on screen showing you exactly where to find it. It takes 2 minutes. It costs you nothing. I do not promote things I have not looked into personally, and this one is legitimate. When the institutions around you are in turmoil, the smartest move is making sure you are personally prepared